Good morning, everyone, and welcome. My name is Megan Guevara, and I am an executive partner at the Pretrial Justice Institute. And I'm really excited to have you all join us today for our conversation on unpacking willful flight. And this comes out of a paper that PJI released a couple of weeks ago, Unpacking Willful Flight, a call for equity-centered reform around bail hearings and missed court dates. This conversation today is a chance to be able to take that paper to the next level and talk with a wonderful group of panelists about what willful flight actually means, how it fits into law and culture in our bail system, and what it might mean to operationalize a standard that looks really narrowly on the likelihood that somebody's going to flee prosecution as opposed to the likelihood that someone is just going to miss a court date. And I am joined today by my colleague, Wendy Shank, who's going to be hanging out with all of you in the chat box. And I see as folks are logging on, we have a lot of amazing pretrial wisdom of the folks who are in the audience. So we welcome your questions, your comments, your thoughts on this subject throughout the conversation today. And now, without further ado, I'd like to welcome our panelists to join me. And we will get started with the conversation. Hello, all, and thank you so much for your time this morning. So I am joined today by Lauren Goulden, who's a professor of law at the Syracuse University College of Law. Welcome, Lauren. And when we started working on this paper, everyone said, well, have you called Lauren Goulden yet? Because she is really the legal scholar in the United States that's working on this subject. So thanks so much for joining us. I'm also joined by Sharon Mitchell with the Cook County Public Defender's Office, and Illinois and the Pretrial Fairness Act were the inspiration for writing this paper. So we're really excited to have Sharon here, who's been involved in the Pretrial Fairness Act since its inception. We're also joined by Nicole Zayas-Manzano from the Bail Project, who was kind enough to step in for Tara Watford, who's feeling under the weather today. But Nicole is the Deputy Director of Policy and involved in so many national policy conversations around bail around the country, and also able to bring to us some of the great research that the Bail Project has done based on the experience of people in the community that they have bonded out. So thanks, Nicole, for being part of this conversation. And Mike Milton with the Freedom Community Center in St. Louis, who also has a lot of on-the-ground experience working with folks who have been very successful in the community on pretrial release, and is going to be able to share some of those experiences with us today. So thank you all. And again, hello to everyone who's joining us virtually. Please feel free to introduce yourself in the chat box and pose questions at any time, and welcome you all to share your experiences as well. All right. And I want to kick it off with Lauren and Sharon, because you did really help get us started with this conversation several months ago. And the Pretrial Fairness Act in Illinois does push for a higher standard related to willful flight versus just any failure to appear. And hopefully we'll be hearing a decision from the Illinois State Supreme Court later this week on the future of the Pretrial Fairness Act. But if it goes into effect, then there will be the question of what does that higher standard look like on the ground? And so Sharon, I'd love for you to start us off by sharing a little bit of that history and why the architects of the Pretrial Fairness Act wanted that higher standard.
Well, thank you all so much for having me here today. It's so great to be with my friends at PJI. Listen, we've been working on these issues for quite some time, but PJI has always been there from really the beginning in helping organizers put together what we think is one of the best pieces of legislation when it comes to pretrial reform. So we thank our friends at PGI for all of your assistance over the years. I think that the standard that we've supported, I think some may call it more strict or a higher burden. I would just call it more realistic, right? The creation of that standard just acknowledges some real truths that anybody who's been around a criminal court system understands, right? While courts certainly have a duty, I think the first is, while courts certainly have a traditional duty to ensure that people appear for courts, we know from all types of literature that pretrial detention is a costly remedy to any problem that the court system acknowledges, right? So if we are over incarcerating people based upon anything, that's a problem for the system. I think the second acknowledgement, the second truth is that, everybody who's been around the court system knows that there is a gap between non-appearance and flight. When I was a when I was a line public defender, I represented thousands of people. Not one of them fled to Morocco. It just did not happen, right? The reality of the system, the reality of the situation is that the vast majority of people who don't show up are not showing up because they're off with their passport, fleeing their, class 3 drug offense. It's just because there's something that exists that did not allow for them to be there. And oftentimes those situations are highly easily remedied. And I think the third thing, it kind of floats into the second, is that there are significant barriers to getting people to court, right? That create non-appearance as opposed to flight, and that systems are better suited to acknowledging and reacting to those issues. So issues like poverty, issues like homelessness, and issues like childcare and issues like elder care matter to a person's life. And especially when we're talking about a system in Cook County where people are having to appear dozens and dozens of times, right, in an area that's not accessible really to public transportation, where you may have to, deal with safety concerns to get to court. Acknowledging that reality is so very important. Before I end, just one more story. I remember practicing at 26 California, our main courthouse. And there's a big sign. These signs actually still exist where it says "No kids in the courtroom," right? And I always thought, like, what did people think? What did judges believe that these kids would go, right? Did they disappear? Like, these responsibilities still exist. So I really think the standard that's been supported by advocates is really just more realistic and really tries to get the gravamen of what the issue is, as opposed to using this one-size-fits-all strategy that's built around pretrial detention, or often feeds us too deeply into pretrial detention.
Thanks so much, Sharon. I appreciate that perspective. Like, this just represents the current reality of what folks are dealing with, both people who are coming to court and as the system is resolving cases. And then this is also not a new radical idea in terms of our legal history as well, and in terms of legal precedent in the United States. And so I'd love to turn to Lauren to ask about, where does willful flight fit in terms of legal framework? And why is this really the more appropriate standard to be following, rather than looking at any failure to appear for folks coming back to court?
Yeah, I mean, I feel like Sharon captured so much of the sort of policy arguments here, which feed right into the legal argument. So, just to say it again, right? If we have a problem, we think it's a problem if people don't show up for court, we should figure out why that's happening and try to develop some precise explanations for the causes of that problem, and then address that, right? Be specific. I think one of the challenges is, we've maybe had a problem of lumping all of these cases together as failures to appear for a long time. I know we'll talk later in the conversation about newer risk assessment tools, but they steer toward that. They, the risk assessment tools want to predict broad categories of non-appearance for reasons we can talk about later. But as a policy matter, we need more precision about what's going on in this situation. And I think obviously PJI's new report has done a nice job of outlining how small the problem of willful flight is in this much larger, or in the bigger picture. As a legal matter, shifting to constitutional arguments, I mean, the bail protections are, the language in the Constitution is thin, but the court has interpreted excessiveness to require precisely this kind of match. If we're thinking about any kind of significant liberty restraint, you have to justify that by showing that, pretrial detention is necessary to achieve that end. If you talk about non-appearance generally and you don't isolate the hard cases or the harder cases, then you have the kind of problem that Sharon already discussed, right? You're more likely to use pretrial detention to address problems that don't require anywhere near that level of intervention. Below the comment, there are other constitutional provisions too, right? Kellen Funk at Columbia, I think, has written well about the range of, due process, equal protection kinds of arguments that advocates make in this context to talk about, why we need to have a standard more like a strict scrutiny standard if we're thinking about imposing any kind of liberty restraints on defendants. But state and federal statutes have included some of these distinctions for a long time too. Most state and federal statutes require the government to use the least intrusive means, or courts to use the least intrusive means to accomplish their objectives. And that requires that you're precise about what your objectives are and precise about what the problems are. I think you can see traditionally, even in the federal statute, a focus on trying to distinguish between different types of risk of flight. So you had the federal statute talk in some instances about a serious risk of flight. But I liked that Sharon already sort of raised the problem with using flight as the label at all in this context. But most of the time, we are not talking about people who are leaving their jurisdiction, and we still use language that misrepresents what the problem is that we're trying to address.
Thanks, Lawrence. There's a lot to unpack in there in terms of, what are the basic constitutional protections that people have when they're coming before the court? What are the standards that we need to have before we deprive someone of their liberty, both detaining someone and then any other surveillance or conditions of release that deprive people of their liberty? And then looking at what are the laws that we actually have in place right now within our states and at the federal level, and what are those laws saying versus what are we doing in practice? And we do have some shout outs for your articles, Lauren, in the chat box already. And I encourage folks to dive in there if you want to get more deeply into the legal arguments behind this. And thank you for what you've brought there. And I know Wendy just put Kellen Funk's article in there as well. So thank you, Wendy. And we've already brought up the fact that when we look at the reasons that people aren't coming to court, for the most part, they are daily barriers and challenges. And Mike and Nicole are both involved with organizations that look at how do we overcome those barriers and what do we need to do to help people to be successful when they're facing those challenges. And we've learned from both of their work that when folks have those supports, for the most part, they are successful. So Nicole, I'd love to look to you first to hear more about what the Bail Project has learned about what it takes to help people come back to court. And when folks have those supports, what do the results look like?
Well, thank you so much for having me as part of this really important conversation. It's really, in many ways, at the heart of what we're trying to show at the Bail Project. We are a national nonprofit organization that provides free bail assistance and community-based pretrial support to thousands of low-income and indigent people every year. Since our launch in 2018, we've helped over 27,000 people in over 30 sites across our country. Our teams get referrals from community members, public defenders, and local partners, and we post bail at no cost to the client or their families. The idea is that we are removing the financial incentive that is at the crux of what cash bail is meant to do. And we then collect a lot of data on getting our clients back to court. What we do is we provide them with court notifications to remind them of when their court hearings are coming up throughout the duration of their case, transportation assistance so that they can get to court if they're having an issue with transportation, and connections to voluntary services and resources based on their needs. We call this model community release with support. And using it, we've supported, again, over 27,000 people in making 91% of their court appearances. Our clients, again, have no financial obligation to us or to the courts. So this is showing that most people will return to court without the burden of cash bail broadly. But from our research and experience with our own clients, we know the reasons that people actually miss their court dates are most commonly confusion about court processes and logistics, lack of transportation, difficulty finding or remembering the information on their next court date, physical health needs for the person or their loved ones, and work conflicts. And genuinely trying to escape prosecution is just notably missing from that list. Courts just don't collect this information granularly, right? They note that somebody has failed to appear, but they don't necessarily know why. And they don't really have processes in place to help people who are facing a challenge get to court. So I remember one client was admitted to the ER the night before his court hearing. He was scheduled for life-saving surgery the next morning. And even in that context, reached out to his public defender and said, what do I do? Public defender very quickly was like, look, you need to stay in the hospital, get your surgery, just miss the appearance. I will go, I will explain the situation. The judge, I think, really understood the next day when the attorney went and explained the situation. It's sort of clear from empathy that the judge was showing in the moment and the lack of a warrant being issued, but still was written down as a failure to appear. And so at the end of the day, that client thankfully got surgery, recuperated, was able to go to the other court appearances that came later in the case, but in the future is going to have that mark against him moving forward. So I think it's really important to understand that the reasons why people miss court, to Sharon's earlier point, are practical and realistic, and you just need to get creative about how to get them back. The Bail Project works on the most common challenges, and we see genuine results.
Yeah, and that's a really great point, and really at the crux of PJI's paper as well, that there's two parts of the conversation here. One is about how we address non-appearance in the moment, and we are seeing a lot more court systems that are recognizing that there's a need for compassion and flexibility here because there are a lot of things that affect people's lives, but changing how that is then recorded and used in future hearings, future bail decisions, we're not there yet. And those kinds of situations can then become a risk factor label for people for a long time because we haven't changed the way we're defining things and the way we're making decisions at those initial bail hearings. And we've seen a couple of comments to that effect in the chat box as well, that we need to be thinking not just about this particular moment, but about the impact that we have on people's lives going forward. And Mike, I'd love to turn to you. Thank you, Nicole, to add from your experience in St. Louis. What are some of the situations you're seeing, and what has had an impact on folks' success?
Sure, happy to answer that question again. Thank you for the invitation. I'm also coming from the grassroots perspective after doing this work since 2017, I think. Also a former member of the Bail Project. One of the things that we have saw pretty distinctly and overwhelmingly is that people generally lean on returning back to court, as everyone has already said. What we have done in St. Louis is that we posted bail for more than 4,000 people across the region. More than 91% of those people return back to court, regardless of charge. So that's another quick point that oftentimes we think about this, we don't think about the seriousness of the situations. In fact, the data shows that the more serious the cases, the more likely people are to return back to court. So that's just point blank period. In that same vein, we've been able to close a jail by devastating the jail population. We reduced the jail population by 81% and crime went down. So also attached to this conversation around willful flight is this danger to public safety when it's actually proven to just be false. People don't return back to court. People return back to court. They don't commit new crimes. They go back to their families, their jobs, and their houses. And one of the things that we have seen more prevalently is that the effects of the legal system and pretrial incarceration has on people's lives, but also reduces the chance of people to return back to court. For an example, one of our first bails that we did, she was a young lady who was held in pretrial confinement for $750. We posted that bail. We waited for her to come out of the jail. We picked her up, took her home, and when she went up to her door, this is like 8 o'clock at night, she went to go put her key in the door and the key didn't work. She walked around her house twice and she saw that her car wasn't there. She came back to my car and asked, can she use my phone? She didn't even have a phone. When she called her landlord told her, unless you pay back the back rent that you owe me since you've been incarcerated, I have put all of your things out and you can no longer live in this residence. Like the violence of the legal system in that moment, I saw it all over her face. When she called her mom, her children were in Minnesota because that's where her mom was. Somebody had to come pick up her kids. Her car was repossessed. And so she eventually had to move to Minnesota with her mother. And so it made it harder for her to return back to court because every single time she had to come to court, she had to buy a plane ticket, right? One thing that we don't consider is the violence of the legal system and how the legal system also is one of the perpetrators of why people don't return back to court. And the last thing I'll add is what we often don't understand, also again on the same lane of the legal system and the violence of the legal system, is the legal system also does not have adequate notification for folks. One of the things we learned through COVID with the backlog of cases is that in St. Louis City, St. Louis County, they were still using the last known address in snail mail in order to notify people of court appearances after all these court appearances have shifted and changed, right? Changed because of COVID after courts have been closed. And so they were mailing people court reminders from 15 with their address from 15 years ago. People were trying to come to the court and they were being turned away because they didn't even know that the court appearance had changed, right? And so one thing that we often don't consider is the violence of the legal system generally, from all the way from from policing to incarceration to prosecution, and the dangerous impact that it have on people's lives, and ultimately how that drives people into devastating situations, which cause them to do devastating things. And we often think of pretrial incarceration in this cycle of willful flight and warrants and all of these things that really harm people's lives as one of the drivers of violence in our communities, because people lose everything.
Thank you for that, Mike. So much in there to reflect on, but important to remember that, as Nicole said, most people are successful. They're coming back. And as you added, they're coming back without committing new crimes in the community. And of course, violent crime is a concern. It's usually the top concern when folks are asked about pretrial release, and all of our experiences as well as the data bears out that most folks are remaining safely in the community. And there are those rare front page stories, but data from all of your organizations, from a lot of great data that's come out of New York State after their bail reform, show that folks who are awaiting trial safely, and that the disruption that you're talking about, Mike, people losing their jobs, people losing their homes, people being separated from their children, those are the factors that in the long run are going to destabilize our communities, that are potentially going to lead to future crime, rather than the guise of protection of pretrial detention. And what are the steps that we need to take to be able to disrupt that cycle and step back and say, what is really going to help people stay safely and stably in the communities as we move forward. And so thank you all for the work that you're doing to be able to help make that happen. And we are seeing more and more of that around the country, more programs that are in place to bring supports to people in the community, to do so in a way that is not linked to surveillance, but is either through community-based organizations or through public defenders' offices, to help to get people back to court and to help to make sure that they have what they need to be able to stay stable during that time period. So if we can move forward in this conversation on that assumption that the vast majority of people are going to come back to court, if those folks have the supports that they need to be successful, they're going to get back to court safely, that even if they do miss a court date, or as Sharon mentioned, sometimes one or two of the many court dates that are part of the disposition of their case, that they're still going to be available to bring that case to closure. And that really we're talking about single digits in terms of percentages of folks that we really may need to be concerned that they are going to flee prosecution and are not be available for the disposition of their case. And now I'd like to bring things back to that initial bail hearing. And if we shifted to a determination where when a judge or magistrate is making a decision, they're trying to figure out, is someone going to be part of those single digits. Is this a person that we do need to be concerned that they're going to flee prosecution? And what it might look like to make the determination with that lens rather than saying, is this person likely to fail to appear for any court appearance? And so, Sharon, I'd like to start with you about what do you think that would look like? What would you like it to look like in Illinois when the Pretrial Fairness Act goes into effect? How should we be defining willful flight? And what should be the distinction that's made at an initial bail hearing to determine if somebody is likely to flee prosecution?
Yeah, the standard in Illinois, I think is fair because it asks court to identify, intentional conduct. It asks courts to identify purpose. It asks courts to actually look into the background of the accused person to explore whether this very, very weighty step should be taken. And I know that the reaction sometimes is, well, that's tough. And I think I would argue that the court is asked to do tough things all the time. The court is asked to make tough decisions all the time. And quite frankly, this would be one decision in a whole series of tough decisions the court is supposed to be making after hearing evidence from both sides. And we're moving away from a bond system that really was quick and fast. And we're kind of, talking as if we're renting the room by the hour, and we're really able to get deep and explore the considerations that need to be considered. I think one of the things that I'm looking forward to as well is the language in Illinois that talks about how just individual examples of non-appearance is not enough, that really we need to be looking at patterns, and really we need to be looking at attentional steps. I think what I'm looking forward to is for this decision to be treated with the seriousness of really a host of other decisions that are made throughout the court process.
Awesome. Thanks, Sharon. We are hoping to have the opportunity to see how that plays out as well. And Lauren, I'd like to ask you to add on to that in terms of anything that you see in the research, in your research, related to what are the factors that should be considered in terms of identifying willful flight versus other behaviors. And as Sharon said, identifying those patterns and what it means to ask the courts to determine willfulness.
Yeah, I mean, I think Sharon explained it well already. We ask courts to make these kinds of determinations in other contexts, so I don't think we need to shy away from that. I think it is a challenge in this space because we have been committed to the idea that certain things are predictive in this with respect to this decision that maybe aren't. Mike touched on this a little bit earlier. If you look at the statutes, they invest a lot in the idea that the seriousness of the offense might predict. It turns out, as Mike said, that the data shows it actually works in the opposite way. The more serious offenses do not result in pretrial failures to appear. And so that creates challenges, obviously, but it certainly suggests that some factors that people might immediately turn to are ones that we should question. I agree with Sharon that, looking at patterns of behavior is likely what people are going to want to do, and isolated prior failures to appear are not particularly meaningful for all the reasons that we've talked about and for all the other things that a prior failure to appear might reflect. But I think this is, I think it's a hard question. I don't know that I have obvious answers about what's likely to predict someone, willfully not appearing in the future. One of the things that I talked about in the article that I think Wendy posted in the chat earlier is that even in cases where courts previously were trying to predict whether someone would flee a jurisdiction, they seemed to feel like it was enough to prove that someone had the ability to flee the jurisdiction, that they had the resources or they had foreign ties or, that kind of thing. And I think we really want to steer away, the ability to flee is useful information, I guess, but we're trying to predict intent or purpose along the lines that Sharon was talking about earlier. So I think you'd be looking for different kinds of tools to use for that.
Thanks, Lauren. And something culturally that we have a hard time with in pretrial is the idea that, like, if there's not a reason to hold someone, if there's not a reason to give someone conditions, that means that we shouldn't be holding someone and we shouldn't be giving them conditions. And so in that case, a lack of information based on legal precedent should mean that folks go home. That should mean that they're
Yes.
released on their own recognizance until we have a reason to believe that that they shouldn't. And that's going to be a very difficult change for us in terms of how those decisions have been made previously, and now the reliance that we've come to have on risk assessment tools and on other types of information to attempt to inform those decisions or to set conditions of release. And I'd love to turn it back to Mike to talk a little bit more about that. What are some of the things that we need to be concerned about that may be seen as proxies for failure to appear, and ultimately proxies for willful flight as well, versus what we might actually know about whether someone's likely to flee prosecution?
Yeah, I'm happy to answer that question. But if I'm being honest, I don't think that's the right question. What I think is the right question is what the courts can do to support the nuances and the complications that people have in their life in order for them to return to court. What's true, and what you said, Megan, which was true, with the caveat that people should be released and go home. That's just all of the data has supported that. All the bail funds have supported that. There's no reasonable rise in violence because of the people who have been released. There's just point blank period. People are supposed to be innocent before proven guilty. In a pretrial phase, they should be at home. And so what I think about when I think about that question, and especially when it comes to returning to courts, is there opportunities for grace periods? Is there opportunities for amnesty? Is there opportunities for partnerships with community-based organizations? Is there an expansion of pretrial offices that considers and talks to the family and the moms and figure out different different places where people are staying? How do we shift the culture away from surveillance and punishment in a pretrial space and context to trust? And that looks like understanding, hearing, and the voices and lives of people and all of they have going on. One of the things that we did in St. Louis County was we initiated this center called Tap In Center, and it's an opportunity for people to come back to court. Come back and after they have missed and talk to a prosecutor and also get access to services, and also walk with an attorney and a liaison with the court, which has shown to be successful. People come back when they have the opportunity to. And so that's more what I'm interested in. What does it look like for us to change the culture, which I know we'll talk about later, change the culture of pretrial the determinations and pretrial sentences in court, not sentences, but pretrial in court, that really should be grounded and rooted in the understanding of the nuances of people's lives.
Thank you for that, Mike. And I think that that's come up in the chat box, that is about culture. And it's also, frankly, just following the law. That's what the Constitution tells us, is that we should be trusting people, we should be releasing them. And that unless there is a compelling reason to do otherwise, that our assumption should be release. And there needs to be a case why not to release someone. And you brought up the point of conversation and having the opportunity to understand what's going on in people's lives. And Sharon mentioned, looking at patterns. And I think, that goes both ways of what are the patterns that we see of folks not coming back to court is one way to look at it. But what are the patterns of the situations and circumstances that just still exist for everyone, from one court date this month to the court date next month, where those challenges are still there. And if we don't offer supports to be able to disrupt that cycle, then we may continue to see a cycle of non-appearance that's not related to willful flight. And I think that will be one of the questions that comes up. And I know, Lauren, it's a question that you raise in your papers as well. What happens for folks who have issues with repeated non-appearance? Do we start just labeling those people as like, well, this, becomes willful flight because obviously they're not interested in getting back to court? Or is this a curiosity question of, what are the continued challenges that this person's facing that we need to do something about if we both want to help them to be more successful and we want to be able to help them fulfill their obligations to the court? and lots of other conversations we can be having about the volume of cases and the reason why there's not time to be able to have those conversations. And what if we just prosecuted less and created some of that time? But we can talk about that another day.
Can I add to that really quickly, Megan?
Yes.
To the exact point, the average length of case is more than a year in St. Louis City. That means that if people are held in pretrial detention, they're in jail for more than a year, which means that people have over 15 court appearances that they have to go to. So it's also the amount of appearances that people are required to come to. That's not even, sometimes the attorney could just go, right? It doesn't even require a person. But then also what that triggers is that it triggers the failure to appear, which ultimately trigger people to, I mean, I'm not people, but law enforcement, and sometimes literally bust into people's houses at 6 o'clock in the morning and bring them out of their houses and hog tie them, right? These are system failures. And so instead of orienting our conversation around how we get people to return, we should be orienting our conversation about how do we fix these system failures that is ultimately triggering this crisis in our cities.
Absolutely. And a few folks in the chat box have brought up COVID, and I'd love to open that up. I know it wasn't one of our planned questions, but what we've learned from that process, where so many systems are still dealing with huge backlogs of cases, and a lot of the points that you've brought up, Mike, related to people don't know when their court date is anymore. They don't know when to come back. It's been such a long time. But there's also a lot that we learned during COVID that we seem to be forgetting, related to when arrest rates went down, when incarceration rates went down, that we did not see a negative impact on public safety in our communities during that time. We had a unexpected experiment that showed us that people could remain safely in the community. And for some reason, we are going back to the way things were before, and those incarceration rates are going up, those arrest rates are going up. If you don't mind me adding in this question, what do you all think we should be taking from what we learned from COVID into this conversation about willful flight? And Nicole, if you don't mind, I'll turn to you first, since we haven't heard your voice in a little while.
I think that's a big question. I'm so incredibly grateful for how many different courts, politicians, stakeholders really recognize the need in COVID to do something differently. And you're right, Megan. What we saw was so many people were released because it was a life-threatening situation to be inside of overcrowded jails. And people came back. We had virtual options. People connected. We had a lot more flexibility enter the system because they understood that as they changed the rules in the moment, people needed more notifications, people needed more contact. All of that happened more during COVID in an emergency situation. And we should be walking away from that, recognizing that people are, to what we really highlighted earlier, trying to get back to court. This presumption that Lauren already highlighted, that people are, if they have any means of getting out, they will, is really not what the evidence is showing us when we do our work, when we do research across the country, when we really look at it. But COVID just showed the entire country that that's also true. And we're quick to forget because I think the system is trying to go back to normal and back to business and back to what it knows. But I do think that this is a moment of real reflection to really learn and to really understand what things we need to be taking into the future of the system and helping it evolve. One of the biggest ones, I think, to Lauren's credit, already she highlighted, is that people aren't trying to just get out, and that shouldn't be the presumption.
Thanks, Nicole. Anyone else want to jump in on that one?
Mike, go ahead. I'll wait for you.
I was gonna wait. I'm trying not to talk too much. So yeah, I think that I've already hinted to this so many times. COVID taught us that so many of these hearings are just not necessary to go to, that there is ways to adjust these situations that meet the everyday lives of people with disabilities, people who have children. The fact that they initiated this, that even the opportunities for Zoom court, not only supported the individual who were, charged of a crime, but it also increased transparency. Now we're able to see the bail hearings, right? And so there is a one thing that we know from COVID, along with everything else, is that the legal system has proven time and time again that it can adjust when if it so chooses to. But oftentimes it does not choose to, because it's rooted in racial violence and white supremacy. And so oftentimes when we think about the impact of COVID and all of the things that that COVID has done or taught us when it came to pretrial justice, is that there's so many different opportunities, and we can be creative with expanding these options for people who are held or who are charged with a crime.
Yeah, I was just going to say that it clearly demonstrates that the court system, which I wouldn't have predicted could be flexible and nimble, is able to when it acknowledges that something is a crisis. So there was collective agreement that the pandemic was a crisis, and we need a little more awareness that the business as usual with pretrial decision making has been a crisis for quite a while. So turning some of that nimble, flexible, supportive energy to this problem would be great.
Thanks, Lauren. And that is definitely true. We all made a lot of changes during COVID that we didn't necessarily expect that we'd be able to make, but we showed that our legal system can make changes when necessary. We can adapt, and that there's continues to be opportunities to do that. But Mike raised the question of the choice that we make, especially around racism and white supremacy in the system. And something else that we're also guilty of is we engage in reforms that we think overall are going to make things better, and we just take racist policy and move it from over here to over here. And there's definitely opportunity to do that with setting a willful flight standard as well, and something that we need to try to anticipate and figure out how we can mitigate upfront. I know one of the concerns I have, Lauren, you raised the point of trying to anticipate somebody's ability or resources to flee. Do we have to be concerned about folks who are immigrants or not citizens of the United States being targeted by willful flight standards because they may have connections outside of the country? Do we know that we have to be concerned about people who are part of migrant workforces that already struggle in the system as being seen as a flight risk because they don't have a housing tie to a particular community? What do you all think that we need to be concerned about in terms of racial bias with a potential willful flight standard, and what are the potential steps we could be taking to not have this be another reform that simply moves racism from one place to another? And Sharon, if you don't mind, I'd like to start with you. Has this been part of the conversation in Illinois, or do you have any particular concerns or plans on addressing racial bias in the context of the Pretrial Fairness Act?
I don't have a lot of hope. I'll be very frank with you. I think racial bias starts right with how we select our judges and how we bring people into the court system and the legal system. And while we're always working on options to kind of slow the flow, the reality of the situation is that if we continue to arrest the same people, right, and we continue to hire the same people to make the same decisions, I'm not sure that we're going to solve the racial bias issue. I think that there are things like data collection that we can look out and really being vigilant about our advocacy, but I don't think that there are any silver bullets in these reforms to disrupting racial bias. I wish I could have a more positive spin on that.
Thanks, Sharon. Anyone else want to jump in on that question?
I'll just highlight. Oh, no, you go ahead, Nicole. I don't mind. Well, I was just going to say, Megan, your new report highlights studies that demonstrate that failure to appear rates, reflect racial bias. And so one of the concerns that I have is that I think it will be very difficult to try to make predictions about willful flight that don't involve reliance on prior failures to appear. And so that's a place where it'll be difficult to disrupt some of the bias that you're talking about.
Thanks, Lauren. Nicole, did you want to jump in?
Yeah, I was just going to highlight one challenge that we'll probably see across the country is how often, generally, our current system looks at proxies through criminal history, right, and history of FTAs to predict out someone's behavior. And in particular, there's a growing number of jurisdictions for turning to pretrial algorithms or risk assessment tools, as they're more commonly known, to also predict that. And they use the same proxies. So the problem is, if we continue to look at these proxies that can't tell the difference between the two of just generic non-appearance or willful flight, then we're always going to predict out something moving forward. And in particular to racial bias, because the system already has a huge history of, and is still currently facing a hugely disproportionate racial disparities inside of itself, you're always going to see, looking back at the history that we already know has these disparities, a disparity moving forward. And so I think the issue is we have to really question the techniques we use and what we're actually looking at, because even if we just change the standard, but we use those same proxies in reality, you'll have the same racial bias result and the racial disparity result.
I know Mike wants to get in on the risk assessment question.
I do. Before I get into that situation, because that's a situation, I want to add on to Nicole's point that discriminatory pretrial practices happen because of discriminatory policing. The whole prison industrial complex, which is rooted in racial violence and white supremacy, I repeat, is a problem from policing to all the way to prosecution to sentencing. And so I have no hope that the legal system will undo itself and undo racial bias, because it's rooted in racial violence and violence. So when I think about how violence happens and how do we address violence, violence happens because public policy created the conditions for violence to grow. So when you don't invest into our school systems, when communities don't have access to quality education, when communities don't have access to quality healthcare, these are the things that causes violence to grow. And so when I think about what does it mean for us to undo bias, one, we have to demand that we invest into communities to stop violence. Two, we have to do a real examination of the prison industrial complex from policing to prosecution on, right? And then secondly, there will be no racial bias in pretrial practices if we just didn't over-arrest, if we just didn't over-incarcerate, if we just didn't hold people in pretrial detention for long periods of time. We wouldn't even have data to discuss that there's racial bias within the legal system if we just didn't practice these discriminatory practices. And when I think about risk assessments, again, to Nicole's point, the idea that somehow we can predict human behavior by factors, by science, by all of these things is just false. Full stop. It's just false. When we look at everything that has been created to try to predict human behavior, they again has turned out racial bias in its very, very, bare basics and roots of the systems. And so when I think about the risk assessments, which I know this is becoming a very popular conversation, especially as they continue to reform these risk assessments. When I think about risk assessments, I think about what does it look like to really predict that somebody would do harm or somebody will flight, and that there is no factors that can reasonably predict those things. And so risk assessments in a sense will be another tool of racial bias, in the same way that GPS monitoring is, in the same way that now we're moving away from GPS, or not we, but people are moving away from GPS monitoring and putting the app on their phone, which suggests that people will even have a phone, or people will even have internet access, right? Or even people want to store their information inside of a system in which everybody will have access to. And so when I think about all of these things, I think, again, I want to talk about how do we reorient it away from, how do we change the system that just cannot be changed, but how do we support individuals so they don't even have to enter the system?
Thank you, Mike. And Sharon and Lauren, did either of you want to weigh in on the risk assessment tool question?
I don't.
I'll just echo some of what Mike said. I mean, I think one of the challenges when you look at risk assessment tools is we don't try to use these tools to predict what sorts of supportive interventions will help people show up to court. We try to use the tools to predict who won't show and talk in terms of risk and figure out how to punish non-compliance. It's not, if we were oriented toward trying to make sure that people showed up for court, all of it would be done differently. One of the things that I've been, frustrated about with the risk assessment tools around predicting non-appearance is, and this ties back to what Mike was saying. I mean, for all of these risk assessment tools, there's a tendency to put like high, medium, low risk labels on things, which inflate the numbers that we're talking about. Even what the claims that the tool designers have about what they're able to predict. So I don't know. I think I'm cynical about risk assessment tools in part when I think about what's happened in the non-appearance space. They just try to predict any future non-appearance because that's the data that they have available. So they just can pull court attendance reports and claim to be able to predict future events. And that doesn't help us go back to sort of the beginning of our conversation to figure out what I want to know is, could you predict that this person has a transportation challenge or this person has a childcare challenge, that the system needs to reorient and be more flexible and sort of adapt to the needs of the people that we want to be showing up, as opposed to trying to find ways to, punish and predict failure.
Thank you all for that. I think, a few big takeaways there around, what we're talking about here is really just a very small slice of the need for much broader reform, change, blowing things up in terms of where racial bias comes into our system, where things are built on structural racism. And until we start at point A, and as Mike mentioned, being able to prevent people coming into contact with the system in the first place, as Sharon mentioned, looking at bias in policing and bias in the court systems and how we make decisions, it's not an issue that we're going to be able to make a dent in overall. And when we look specifically at that lens of willful flight, we need to be thinking about how we're making decisions and about the data that we're bringing into those decisions, and whether or not it's possible for us to continue making decisions in the same way, in a way that removes bias. And we know that, as Nicole mentioned, that there's bias baked into the data that we use in risk assessment tools. And we also know that we don't have risk assessment tools that can predict the very rare events of willful flight. And Mike also added that layer of violent crime that when we think about what communities are concerned about, usually they're concerned about violence, and understandably so. But we're not making decisions based on an understanding of the likelihood that somebody is going to commit a violent crime. And instead, we're just putting folks in a position where they're less stable and more likely to commit a crime later on down the line as a result of our pretrial decisions. So there's a lot that we need to be unpacking in order to be able to better understand that. And as all of you have said at some point in this conversation, to really be able to back things up and change our frame to how do we support people and how do we support them when they are free in their communities, rather than looking for the information that's going to tell us whether they're likely to fail. And I want to start taking questions from the audience, but I also do want to, before we do that, go back to the question of culture. And it's come up for a lot of folks in the chat. It's also come up here that this is a fundamental shift in the way that we look at people. Mike brought up the issue of trust, whether we trust people to stay safely in the community, whether we believe that at the end of the day, folks want to get back to court and they want to fulfill their obligations, and whether we're willing to put that trust in folks and to ultimately believe that there's going to be benefits to our community by increasing pretrial freedom. And that's a big change for a system that historically has tended to view more we assume that we're going to detain or surveil someone unless we have a reason not to, rather than the other way around. But we also know that there are a lot of folks in communities around the country that are making those shifts, that are looking at things differently, folks in the system that are starting to engage community members, to listen to the voices of people who've been impacted by the system and to make those changes. So we know it's possible. And I'd love to hear from all of you, folks who are engaged in that work and have seen those changes in some of the communities that you're working with. What does that culture change look like? And what do you think are some of the things that we all should be considering as we work locally and try to bring those changes about? And I open that up to anyone who'd like to respond.
Happy to jump in first. I think we've named a few along the way here, but certainly from our own work here at the Bail Project, I think a real shift in the mindset around what the court's responsibility is in helping someone get back to court is probably just a huge culture shift that needs to happen. It is no longer evidenced by everything we've talked about and seen, the data that we know, safe to presume people are trying to just disrespect the court by not showing up or trying to escape prosecution, right? I think we have to accept the realities that we've all been talking about so far today and the practical issues that make going back to court hard. To things that we've already seen here, courts are probably starting to have those shifts. Individual judges, I think even the one I highlighted in my story, could understand the situation, but the court process, the court data system wasn't able to actually note why someone didn't appear and sort of note that it was not willful flight, right? There is simply the category of failure to appear, and it was checked, even though there was no warrant issued, even though everybody in the courtroom heard why, understood it, believed it, and moved on, right? So I think in some ways we have to shift the court system to take on things like court reminders, create systems of communication with people so that there's a bit of a two-way conversation where you can say to the court, hey, I'm in the ER. I know I have a hearing tomorrow. I don't know what to do, right? To help with transportation assistance, essentially, the court needs to just be able to understand that it's its responsibility to figure out why people might miss court and to help them actually get there. We see this in other fields altogether. I can't have a doctor's appointment where I don't get like 5 reminders at this point that my appointment is coming up. Please come. I get a phone call that day. Please come. It's a real burden to us when you don't, right? Courts are capable of doing that too, but it takes that flexibility that we did see during COVID. So we know that they're capable. And while there are judges who are starting to do this, the entire system has to evolve to help support that culture shift.
Thanks, Nicole. Anyone else want to jump in on the culture question?
I say really quickly that again, just to kind of beat the drum, that if we change the system, if we change the culture away from punishment and more about accountability, it would actually cause us to lean more on community-based organizations to address what's happening between the complicated situation that led to a charging. So I'll start there. Then I go to also, is there opportunities for grace periods? Is there opportunity for amnesty? Is there opportunity for people to come back to court without punishment? And that changes the relationship from the community to the courts, which people won't have to flee. If they can trust that it doesn't mean more punishment, if they can trust that it doesn't mean more surveillance. I mean, the amount of people who tell us, that we have, that have been released us, we sponsor release for folks, and they put GPS monitor on them, like that means humans have to literally plug themselves up into a wall like a computer. And the slightest fraction, the slightest anything that happens with this device, it triggers a warrant, right? If we just change the culture away from this punishment-centered view, it has the possibility to increase the community's trust that they can solve this issue, because that's what we're seeing. Most people just want to get it over with. They want to get it done. A lot of people even has said to us, because we do restorative justice, is that people they actually want to face the person that they harmed. And they want to say sorry, and they want to do sorry, and they want to practically repair. So even the idea that people just want to fly, just want to run away, is just wrong, generally. Common just report that 90% of survivors all choose an option of an alternative to the legal system that's rooted in restorative justice. versus the legal system. 60% of survivors drop out of the prosecutory process before grand jury. They don't continue on with the case. So it also doesn't serve survivors. So what does it look like for us to change the culture around actually solving the issue that's not rooted in caging Black people and caging poor people?
I appreciate that, Mike, because it does get into one of the questions that came up in the chat box related to survivors and victims. And I appreciate the point you raised about punishment versus accountability. And we also had a question in the chat box. So what about folks who do commit a new crime when they are on pretrial release? How do we respond to that? And Sharon, I'd like to turn to you first, because I know that victims' rights groups were a big part of the conversation in Illinois around the Pretrial Fairness Act. And what are your thoughts about how willful flight standards specifically, but some of the other responses to non-appearance also that we've been talking about, how does that fit in with meeting the needs of people who have been, who are survivors of crime?
Yeah, oftentimes in these debates, we build these straw men as if the current system is good for victims. The reality of the situation is that it wasn't particularly, well, I'll say this. I want to give a big shout out to Sarah Stout, who just changed positions. She was with us at Chicago Appleseed and now is moved on to a new institution. I think she's a great person to talk to when talking about the conversations we had with victims' rights groups. But the reality of the situation, the reason why it wasn't impossible is because the current system screws victims over. The idea that there is a dollar amount, right, that can be paid, and that dollar amount would suddenly make you suddenly unrisky is not a system that works for people who are concerned about victimhood. I think it is also a reality is that as public defenders, we represent a whole lot of victims. And this idea that there is some bright line between victims and perpetrators, I think makes sense in the fake policy world, but when you actually go down to the street and you go down to the courthouse and you talk to people, you realize that that is something that is a fanciful construction. When we're talking about, every single person, certainly there are, grays and blacks and whites, but there are lots and lots of folks who find themselves in the criminal legal system or victims who are accused of them offenses. I think the one other thing that we should talk about, and there's lots of good conversation in the chat, is that these reforms are not going to solve everything, right? I think the goal for advocates have been to move the system forward. And I think there's going to be lots of issues when it comes to getting judges to kind of do the right thing. I think having better law is helpful for defenders. And I think having the ability to appeal and use the appellate process to enforce hard-earned interpretations of the law is also going to be something that's important. I think the final thing, and it's going to be harder in certain jurisdictions, is to really think deeply about culture change and really be working with the judiciary, working with stakeholders. And again, this is going to be impossible in some places, to try to think about how do I put this? There's a law, right? And there is how the law is interpreted. And people respond to pressure, right? And a lot of times the other side uses that pressure to force people into being more carceral and more punitive. I think there is an opportunity in the current state of the world to use pressure on the other side, right? To organize and push stakeholders to make decisions that are more reflective of the community's well-being.
Thanks for that, Sharon. And I welcome folks in the audience to please add questions to the chat box. I know we've had a lot of conversation. I've been trying to keep an eye out for questions as we go, but there's a lot in there. So please feel free to pop anything in there that you'd like to hear from our panelists on. And I would like to go back to that question of, well, what if someone does commit a crime? And Sharon just made the point that, we're not going to have a reform or a version of the system that's going to be perfect. And Mike has also framed violence in a lot of different ways in this conversation. And that when we think about the likelihood of violence there's a likelihood of violence happening when folks are in the community, and there's also a high likelihood of violence happening when people are incarcerated. And so we need to be thinking about that balance as well. And the question of how many people do we want to deprive of their liberty to potentially prevent one high profile crime in our community? You know, how many people are we willing to deprive of their constitutional rights in order to make that happen? And I know that I frequently get calls from reporters saying, you know, will PJI comment on this one, you know, particularly horrible thing that happens? And, you know, here was this person that had a criminal record a mile long. They were out in the community and they did something terrible. And the fact that that terrible thing happened is awful. And the fact that there were people that were impacted by that is terrible. And then the question I ask is, if this person has been repeatedly incarcerated over the course of their lives, and we're now asking the question whether incarcerating them again is going to fix that problem that we're seeing, you know, that's the definition of insanity, that we're continuing to go back to that same solution. And saying, I've been doing this work for 20 years now, and saying, if I had had the ability to interact with that person 20 years ago when I was getting started as a community health educator, what were different things that could have been done at that early point? And even if we're dealing with the end process now, who are the other young people in our communities that we could be working with differently now, so that I don't have to continue to have those conversations in another 20 years about this person. And all of our panelists have brought that up today, of we need to be stepping back and having a different conversation. This is the opportunity for us to start having those different conversations. Mike, you want to jump in?
Yeah, I want to say to your point, Megan, which was so brilliantly articulated. The main drivers of why violence happens is shame, isolation, inability to meet your own economic needs, and exposure to violence. That's literally baked into our legal system in pretrial Cajun and Cajun generally. Like, I shame you for what you've done. I don't have to face it. I isolate you from your family, the people that you love, your father, your mom, your dad, your kids, right? I'm exposed to violence, which is the bedrock of our jails, right? And then when I get out, it's harder for us to get a job, right? So the same thing that we hope that caging would do to address violence actually drives it. Caging generates violence in our communities. And so what does it mean? What process do we have when people commit harm in our communities? It should be a process, a community-centered process, in which a person who did the harm can be accountable for it, which means that they are acknowledging the consequences of their harm. It means that they are doing the hard work to never harm anyone ever again. It means that they're willing to repair the harm designed by the survivor. So the answer, I think the answer to that question of what happens if harm actually happens, well, we need a whole different process, right? That actually serves survivors and what they want, that centers survivors and what they need, that helps them in their healing, and actually help people who do harm never do that harm again. And so the answer for me will never be the legal system. It will always be an alternative system in which we can design that addresses the violence in a way that actually leads to accountability versus punishment, which we know generates violence in our communities.
I'll add one more thing to that. I think that's a beautiful. I'm gonna steal that, brother. I'm just gonna tell you. I'm gonna tell you now. I'm gonna steal it. I'm gonna be saying it. Sometimes I'm gonna attribute it to you. Sometimes I'm gonna forget. But that's just a beautiful characterization of why we have violence. I think another thing is when we make these decisions, sometimes we frame these decisions on detention, pretrial detention especially, as like they're not cost-benefit analysis. They're just like benefit analysis, right? So we look at this decision essentially as, well, if we incarcerate the person, then we avoid X harm. And the reality of the situation is that when we make a detention decision, we are harming the community. Now, we can have a debate back and forth about whether those costs are worth it, but there are costs associated. And coming from a county where I think 13 people have died in the jail this year, this idea that putting somebody in the jail is just like, well, you know, we can save a life. It's just not really looking at the situation with incredible seriousness that it requires, right? So I think one of the things that reformers and abolitionists and advocates in Chicago have been successful in is really talking about the costs of incarceration, the costs to communities, right? People who live in communities, talk about how taking so many young people out of the community or young fathers out of the community, what effect that has on the community's health. As a person who's living in some of the communities or born in some of the communities that people talk about, I want our communities to be safer, right? And it's not just about us responding to seem like we're tough, but to actually be safer. And I think that that's something that's sometimes missing in the debate.
I definitely agree. I think that in many ways too, it's just that mass incarceration writ large has taken on so many resources and self-perpetuates, right? And it creates this violence and then it responds to the violence. At the end of the day, we have to stop funding this huge carceral system and funding all of these responses that create a cycle of violence, and instead reinvest in our communities. And it's not a matter of taking funding away from a whole bunch of people who are trying to do good. It's a matter of putting the resources where they're really needed, where they're most impactful, and asking these stakeholders, hey, the community is no longer asking you to be responsible for reacting to these things. We're taking that off of your plate because we think that there's a better way. And we're gonna have to experiment and figure out what that looks like. But Mike's right, it looks different than responding with something that we know creates even more harm at the end of the day. It's something that we have to hit pause and stop reacting with the same exact response.
Yeah, I recently had a conversation with a prosecutor in upstate New York who was talking about, one of his big complaints for upstate counties, and I'm not sure how true this is across the board, is that there was a sense that with New York's bail reform, there would be all this investment in some of the supportive non-criminal justice resources that Nicole was just talking about, and that, at least in some counties, they haven't seen that. So they, feel like they haven't had the ability to rely on other tools. And I was just also struck in that conversation about the difficulty that people have trying to reorient, so we've had a long investment in diversion courts as a way to get people who need drug treatment into drug treatment programs. And it's very difficult for people who only see a criminal justice path to that end to try to reorient to figure out how to get people treatment who need treatment without using the criminal justice system as the stick to compel them to go there. So it feels like a conversation that's much bigger, of course, than this issue. But
absolutely. And it seems like every time we have one of these conversations, we end up with conversations that are bigger than this one issue. And it speaks to the complexity of the work that we're all trying to do and the need to make those changes on multiple fronts. And we all know from our experience that, small tweaks to the pretrial process, to the criminal legal system as a whole, has not gotten us the outcomes that we want. That this needs to be one facet of a broader, more cohesive plan to be able to make those changes. And we do have a couple of more specific questions from the audience I'd like to pull on in our last few minutes. But we have a question coming out of Virginia about the idea of when there is a separate charge that someone is given for failure to appear. It's called bail jumping in some places, and sometimes you're charged for bail. The consequences for a charge of bail jumping are more severe than what the underlying charge was. And that could result from some of the non-appearance situations that we've all been talking about. And so Macy is asking, do any of you know of places that have worked to eliminate failure to appear or bail jumping as a separate criminal offense? Or if that is work that's underway in any of the places that you all have been working? And Nicole, I'll put that to you first, since I know you have your ear to the ground in lots of different places in the country.
Well, what comes to mind immediately is that I think they're ready to, in many places. I certainly saw a bill in Texas this year come up that was going to create a sort of extra layer to it. It was going to create a new criminal offense for any condition of release being broken, including failure to appear, which was redundant with a bail jumping charge that was that's already there. And I was shocked and frustrated because of all of the reasons we've talked about here, not to mention the redundancy with another charge that already exists in there. But I was actually really interested in seeing how legislators talked about the issue, because they are actually very quick to point out that the realities were just too difficult and this was really attacking something that didn't make sense. They didn't talk about the fact that bail jumping was already an issue there, but everything they talked about was applicable. So I actually think that policymakers across the country might be ready to have that kind of conversation. What they need is a sense of what we're talking about, that willful flight is distinct from non-appearance, and that it's possible to try to hone in on one instead of the giant category. When I talk to policymakers across the country, they sort of naturally understand that, but then they're very quick to refer back to system stakeholders who are saying, well, I don't know how I would do that. And instead of engaging in that conversation about how, and let's figure it out together, policymakers sort of back away. But I think they're at the point where they're very open to the conversation, but they need to understand that non-appearance is not the same thing as willful flight. And they need folks to really speak up and say that from across the country, whether they're constituents or experts, the data that we have. I think that it's time for that conversation for sure. And thank you for lifting it up.
Thanks, Nicole. Yes, and it does bring up something that we haven't talked about much yet in this conversation, but the statutory framework that folks are working in, as well as the local cultural framework that you're working in, are both important to the question of being able to make that shift from willful flight or to willful flight from failure to appear. And in some states, willful flight is already in the statute, and it's just a matter of following the laws that already exist more tightly. And in some places, it would be statutory advocacy to be able to make those changes. And then we also had a question that came up a little earlier in the conversation related to what information do public defenders have available to be able to combat an allegation of willful flight? And so Sharon, if you don't mind, I'll put that to you of, at the individual case level, what are some of the arguments that might be made to push back against the idea that somebody is going to be fleeing?
Well, I think the first important thing is, and I think Charlotte from our policy team talked about it in the chat, is that the law does include an obligation for the state's attorney or the law enforcement to produce the information that they are going to be relying on to making this argument, right? So having the same amount of information that the prosecution has when they make this argument, I think creates a level playing field. And I think at that point, we're just relying on the actual standard in the law, right? That basically highlights that simple non-appearance, right? Is not enough, right? That we are essentially responding to the prosecution's assertion making the arguments that we have from both the information that we have before us and the conversations that we have with the client, and then also relying on hopefully the appellate process as a backstop to enforce strong decision making.
Thanks so much, Sharon. And we're getting close to our closing time, and I want to give each of our panelists the opportunity to have a closing comment, anything else that you want to make sure you have the chance to say before we close out the conversation. But I also want to extend an invitation to the 150 or so folks that joined us today, that we really see this as the beginning of a conversation at PJI, and we know that there's still so many things to talk about to unpack this issue. And we also hope to be able to work with some communities around what would it look like to implement a willful flight standard locally. So we'd love for all of you to stay in touch with us, either through social media or reaching out to myself if you'd like to talk more. And also, I know that there's been some connecting happening between different communities in the chat box, but especially if you're potentially interested in being a pilot site to work on willful flight issues, we'd love to be able to touch base with you. And with that, I will turn to our panelists for their closing comments. And Lauren, I'll look to you to kick us off.
I just want to say thank you. This has been a great conversation, and I feel like people have touched on all the sort of big important themes about, you're leading us to talk about how to change the culture in this space and how to reframe the conversation. I feel like it's such an important piece of this. I'm definitely continuing to work on issues around pretrial appearance. And so I'll just ask if people have projects they're working on that talk about strategies for getting people back to court that we didn't raise in this conversation. Please don't hesitate to reach out to me. I'd love to hear more about what you're working on. I just appreciate PJI's work in bringing people together for this conversation.
Thanks, Lauren. Mike?
I was hoping you weren't going to call on me yet because I didn't know I had my thoughts. But I'll say quickly, I would challenge all listeners, including myself too, to do a real evaluation of our personal ideologies around these things, and to really connect with individuals who are caught in these cycles and listen to their stories, and be encouraged by them, and allow empathy to challenge your ideologies. I truly believe, and I know this because of the thousands of people that I've supported, and also I'm formerly incarcerated myself, but I truly believe that we keep us safe. Our communities can keep us safe, and we are creative and we're ingenuitive, and we can do it. Only if we sought to find a way to create our systems of safety ourselves. And so I just would challenge you to not believe the lies of the legal system that tells us that caging is necessary. I would challenge you to really listen to the people who are directly impacted by these things, and hear their stories. Yep, that's all I'll say.
All right, thanks so much, Mike. Nicole?
Well, thank you again for having me be a part of this conversation. I think, like Mike, I'm trying to summarize all of my thoughts in my head really quickly. And I guess the thing that is coming to mind the most is that there's not enough attention on this particular issue. I work in a lot of states across the country, and when we start talking about what the standard should be, there's a lot of pushback to the idea of it just being willful flight, often because of how challenging it can be for a court to figure out the difference. But it's important. It's about liberty. It's about our American values, right? And so I think we have to challenge ourselves to actually hone in on the real issue and help people. Otherwise, to Mike's point, talk to people who are actually impacted. The reasons people can't come to court are so human at the end of the day. And it's very hard to watch the system just treat people like they're not people. And I think that that's what it does right now, and it has to change. The laws have to change, but the practices also have to change. So there has to be a really huge shift. And I'm mainly hoping that this is only the beginning of a conversation where we highlight this particular issue as much as possible. I urge everybody to learn more. And if you want a place to start, bailproject.org really hones in on our model, the reasons why our clients can't make it to court, and the ways in which we think that community release with support could work if our court system adopted it.
Thanks, Nicole. And Sharon.
I'm really going to be glad when we don't have to do that anymore. Listen, I just want to thank PJI for this conversation, bringing folks together to kind of talk about strategies. I think is one of the top pieces in the chessboard for advocates who are looking to change the law. It's certainly something that we did in Illinois, looking to other jurisdictions to see what works and what doesn't, and what arguments have been made and what arguments haven't. So I'm just really, really, really grateful for the space and the opportunity to connect with some folks from across the country. I think we're making some connections in the chat right now. So once again, thank you so much. And we really look forward to being a part of the bigger team when it comes to fighting for the reforms that the accused people that we represent deserve.
Thanks so much, Sharon. Thank you to everyone on the panel. I've so appreciated the wisdom in this conversation. And thank you for all of the wisdom in the chat box as well. So many colleagues that are making contributions to wonderful conversations there. And we look forward to where this goes, and hopefully this being another step on the pathway towards a system that defaults to liberty, and a system that is committed to what we know truly makes everyone safe, and this being one of the steps in that process. But please stay in touch and look forward to where the conversation goes from here. And thank you again to everyone for your time this morning. Take care.